Right, it's 5 minutes after our start time. I think we'll get started. Hi, everyone. First, I'd like to start by thanking all of you for joining us today. I also want to extend a big thank you to our partners at American Gateways for doing this with us. This has been a part of a three-series Know Your Rights webinar series that we've done. Today, the conversation will be options available to folks that are experiencing violence, and I'll let the attorneys share information about that. Before we get started, I just want to, I know many of the participants are aware of AFSSA. AFSSA, which stands for the Asian Family Support Services of Austin. We are a Central Texas based nonprofit. We've been here for close to 30 years. And we serve primarily immigrant and refugee survivors of violence. We serve folks that are experiencing domestic violence and sexual violence. And our services are available in a range of languages and are culturally grounded. So most of our staff come from various populations and communities that we serve. We've also, over the years, developed a way of a culturally grounded way of providing our services. Our programs include everything from immediate assistance, so folks that are in danger might call our hotline, and our advocates will guide them through the process of leaving, getting housing, securing sort of all of the pieces that someone has to take care of if they are in that type of an emergency. And we also offer medium and long-term services. A lot of our clients need immigration legal assistance, and we work with a range of pro bono partners and legal aid, including American Gateways, to get folks the legal representation that they need. We also have a therapeutic counseling program for survivors and children. So really, we aim to be a place where all of the various needs of folks can get met. And the services that we don't offer, we work really closely with partners to get folks connected to that type of assistance. So with that, I will pass it on to Annabelle and Meredith. Please introduce yourself, and then let's jump in.
Hi, my name is Annabelle Watson, and I'm a staff attorney with American Gateways. And like we were introduced, we're going to talk to you today about U visas and VAWAs. So what they are, who qualifies, and how they work. And I'm here with my my colleague Mary Soniat, who's also going to present with me today.
Hi everyone, thanks for joining us.
One quick thing I forgot to mention is type in your questions into the chat. Manik and I will be monitoring that, and we'll pose the questions at the opportune times. If you'd like, you can also save questions till the end, and I'm sure our panelists will be happy to take those questions.
So a little bit about American Gateways. We are a nonprofit organization founded in 1987, advocating for the rights of immigrants. We serve primarily free and low cost. Most of our clients come from low income backgrounds, and our service area covers 23 counties in Central Texas.
So what we do at American Gateway fields of legal services. So we provide legal services to help those who are seeking asylum, and we also do work in detention centers. We also help individuals file family petitions and citizenship petitions.
So go ahead.
Go ahead, Mary.
Presentation is, we're going to be talking about U visas or U non-immigrant visas, as well as protection under the Violence Against Women Act. These are both forms of relief available to victims of crime in the US. And we're going to go into detail about the statutory eligibility requirements for each of those forms of relief, kicking it off with the U visa. So what is a U visa? It is a type of immigration application to help victims of crime in the United States. And it was created in order to help immigrant victims that are the witnesses of crimes or the direct victims of crimes or indirect victims of crimes, so that they feel comfortable coming forward and assisting in the prosecution and investigation of crimes.
So who qualifies for the U visa? So immigrants who are victims of certain crimes qualify to apply for the U visa. There's some requirements. So the crime must have occurred in the United States. The victim must have helped during the investigation or prosecution of the crime. And we'll go into detail about each one of these factors further on in the presentation, but these are the general factors. The crime must have caused considerable physical and mental harm, and a qualifying official must issue a certification stating that you helped the police or prosecutor in the case, that you are still helping, or that you will help in the future.
So not all it has to be one of the statutorily enumerated crimes or something substantially similar. And we won't read all of them, but they're usually pretty serious crimes such as domestic abuse, assault, kidnapping, things of that nature.
And also please know that, an attempt, so if someone attempts one of these crimes, or there's a conspiracy to commit one of these crimes against an individual, that may also qualify an individual to apply for U visa protection.
So we have a number of examples to show the variety and breadth of the types of crimes that can qualify someone to be eligible for a U visa. So let's read this one together. Anjali found out she was the victim of identity theft. Oh, sorry, I can't see it. When her credit card bill showed over $10,000 in charges and she did not make. As a result, she had to spend numerous hours setting the record straight. Is Anjali eligible for a U visa? So probably not. While Anjali may have suffered emotional harm or because of the identity theft, that's not a qualifying crime.
Yes, and so, and we do want to highlight that Anjali was a victim of a crime. So it's very unfortunate that something like this happened, but unfortunately this is not one of the crimes that rises to the level of U visa protection. And also, like another point of analysis is the level of physical or emotional harm. And although, again, we don't want to minimize what happened to Anjali, this may not be something that qualifies for a U visa.
Example number 2, Marco was held up at gunpoint while he was pumping gas. His attacker then hit him with the gun and repeatedly kicked him. He called the police after the attack and provided a description to the police. He sustained a concussion and abrasions and was eligible for a U visa. So this one is, this type of crime likely qualifies Marco for a U visa because of the nature of the crime, but it would still require some analysis.
Yes, and it's really important to kind of look at this situation. And he was assaulted, so we can go back and look at the list of what happened. He was assaulted. He was assaulted with a gun, so that may raise it to a level of felonious assault. So yes.
All right, last example about the statutory qualifying crimes. So Stephanie worked at the local homeless shelter. A man rejected from the program called her names and said that he was going to kill her. One of her coworkers had seen the man get into physical fights with others at the shelter and encouraged her to call the police, which she did. The man returned to the shelter 2 times the following week, approaching Stephanie each time, calling her names. She reported him to the police each time he returned. Is Stephanie eligible for a U visa? So possibly. So stalking is one of the qualifying crimes, but this is going to be a fact-specific analysis, as every crime is.
Yes. And also, so one, we're going to look at the type of activity that was that she was subjected to. So like Mary mentioned, stalking is something that is covered. It is one of the enumerated crimes in the statute. And I mean, there's multiple points of analysis, but when we look at an example like this, we're also going to see that she participated, or she cooperated with police. She attempted to report the crime. And also, eventually in the analysis, we're going to look at the emotional harm that she sustained because of this activity. So in this case, we do believe Stephanie could qualify for a U visa. So how does a U visa work? So a U visa is an administrative case, and so you don't have to go before an immigration judge to file a U visa application. And it can, and it's an application that you file with immigration by mail, and no interview is required. So typically what is included in a U visa application, so it's a specific designated by USCIS, and it includes many points of information, but mainly the person's biographical information and immigration history. It's also going to ask, we're also going to include a statement of the experience of the victim, how that person helped the police or prosecutor in the case. And also, importantly, how the crime affected that individual. So whether there was physical harm or emotional harm to the individual. So we're also going to look at documents that prove the person's moral character, because that's another ground that USCIS looks at, and also the harm that the person suffered, were proof of that harm.
So let's talk a little bit more in detail about some of the evidentiary requirements for a U visa, and really what's critical for a U visa. So the law enforcement certification, like Annabelle mentioned, is the first step in all U visa applications, and it cannot happen without a law enforcement certification. So what it is a document signed by a law enforcement agency that certifies that you were indeed the victim of a qualifying crime, and that you were helpful in that investigation, and that or that you continue to be helpful either in the past or in the future.
We're going to dig in a little more into that law enforcement certification. So like Mary mentioned, it's going to show that that you assisted in the prosecution case, or or that you will assist in the future. So who signs that certification? Typically, it's a police department, a prosecutor that's in charge of the case, a judge, or another entity, or another person that's qualified to certify within a specific agency. It's important to note that if you do receive a type of certification, it does expire. So 6 months after that certification is issued, it will expire. So like Mary mentioned, without a signed and valid certification, an individual is not eligible for a U visa. And another important note is that police and prosecutors are not required to sign a certification for every victim. So it's up to each law enforcement agency's discretion as to whether or not they're going to offer certifications to the victim. So this varies city by city, county by county, state by state, and each agency is going to have a different policy about whether or not they're going to certify a case. So the law enforcement certification is critical, and without it, the case can't move forward. So we've got an example. Kenji was the victim of kidnapping 20 years ago, many years before Congress created the U visa. Kenji helped the police in the investigation and prosecution of the crime, and his kidnapper went to prison. Kenji only found out about the U visa recently. He wants to know if he can apply for a U visa. So in this case, by looking at these facts, Kenji qualifies. So he was a victim of a qualifying crime, which was kidnapping. He assisted police and prosecution in the investigation and prosecution, my apologies, of the case. Even though it's 20 years later, a person can go to that entity and ask for certification. The only thing is, if the law enforcement entity or the entity that's going to certify doesn't issue that certification, even though he meets all of the requirements, he will most likely not be able to move forward with the U visa case. So this is one of those examples where there's all the elements may be met, but without that law enforcement certification, the case will not be able to move forward.
So here's another type of one. Donna's husband has been physically abusing her for years, so she left him 6 months ago. She would like to apply for a U visa as the victim of domestic abuse. However, she never contacted the police to report the crime because she had always been afraid that if she contacted law enforcement, she could be deported. She wants to know if she's eligible for a U visa. So this is a type of case that we unfortunately see quite often. And the answer is it depends. So Donna may very well be eligible for a U visa if she is willing to come forward and report the abuse that she suffered. This all potentially eligible U visa applicants should weigh those risks and benefits, and that's something that your legal advocate is poised to help you do through holistic legal services, and there are other supportive agencies that are equipped to help you work out those risks and benefits.
Because she may not have been in a position at the time that the physical abuse was occurring to be able to report, but maybe now she's in a safe space in which she feels that she can report this. And this is another case that, you know, we strongly would encourage Donna to talk to a legal representative because, you know, an attempt can be made to either report to report what happened to her. But again, it's going to be at the discretion of law enforcement if she does report, whether one, they're going to act on the case, or prosecution, whether they're going to act on the case, and if they do act on the case, then whether it's going to get certified. So, you know, again, she qualifies, like what happened to her, the underlying crime qualifies, but it all hinges on that cert.
So we'll read one last example about qualifying crimes. So Martin came to the United States from Cuba when he was 10 years old with his uncle. Martin was the victim of sexual abuse when he was a teenager. Because of the sexual abuse, he's been diagnosed with severe depression and PTSD. One day, Martin robbed a store in the mall and was arrested and convicted of misdemeanor theft. He was also hanging out with the wrong crowd, and he was with them when they stole a car, and he was convicted of grand theft auto and received a sentence of 2 years. After his sentence, he was placed in removal proceedings and deported to Cuba. Martin returns to the United States. Can he still qualify for a U visa? So This one touches on a number of different interesting facts about the U visa. And yes, so someone who has a criminal history can still qualify for a U visa. And also someone who has been deported in the past can also still qualify for a U visa. So those are good things to note.
Mm-hmm. And that's what we kind of wanted to show in this example is what Mary mentioned. But the common theme through the examples that we've provided are that, you know, again, it all depends on whether law enforcement certification can be issued or will be issued on cases. So again, Martin could qualify, meet all the requirements, but without the law enforcement certification, the case can't go forward. So again, that's why it's so important to talk to a legal practitioner and about a case because, you know, they may be able to assist. So what does the U visa do? So what are the benefits of an approved application? These are some points. So it'll grant legal status in the United States for 4 years. The person will receive an employment permit for 4 years. The person may receive protection from deportation at a certain point, and the person will be eligible to apply for residency after 3 years.
And also there are potential derivatives on U visas as well. So someone's spouse or children can also receive protection, even if they weren't the victims of a crime. If their spouse was or their children were, they may also be able to receive benefits.
And we will have a slide on that in 1 or 2 slides from now. The application process, what does that look like and what's the waiting time? So we're not going to read everything on this slide. It just kind of gives you points, but the U visa process is a long process because immigration only approves 10,000 applications each year for the entire country. You know, an important milestone is that 3 to 4 years after applying for the U visa, if the person receives a provisional approval, then at that point they may receive protection from deportation and employment authorization. So it is important to note that while the application is pending, the applicant will still be undocumented. So entering and leaving the United States will affect their case. And another thing that will affect the case is any criminal arrests that happen.
Okay, so let's the timeline for a U visa, because it's extremely important to keep this in mind when someone applies, because it's not an immediate form of relief. It takes a considerable amount of time. So Ariel submitted her U visa application on January 16th, 2016. When is she going to receive status? Since the cap for the fiscal year 2016 was reached in December 2015, Ariel cannot be granted U status in 2016. So, and this is because of the cap. So it is probably likely that by the time Ariel's application is deemed approvable by USCIS, at the current adjudication time of 10 to 18 months, the U status cap will have been reached for the fiscal year 2017 and 18, and maybe even 19. So Ariel on the wait list and granted deferred action until a status is available for her. So clients, it's not unheard of for a U visa to take many, many years.
Yeah, and that's so important to highlight, just because, you know, their time will go by. And so that's why we kind of stated what we did before, you know, during the time that it's not approved, the person will still needs to be mindful of, you know, of entering and leaving the United States or criminal arrests.
We actually have a question, and I think you've answered it. So if you want to just clarify, it's a question from Karen. Can a victim apply from abroad if they've been deported? They assisting law enforcement.
I think we may have to get back to that. I don't know that we have an answer for that one. Do you, Mary?
Yes, I think yes, that is true. As long as the criminal activity occurred in the United States and they've since been deported or they voluntarily left, you can still, there are some qualifiers, but you can still pursue the U from abroad.
Thank you, Mary.
We'll make sure that we put the information for American Gateways so you can give them a call.
So like Mary mentioned, there are the possibility of having derivatives on a U visa. So, so family members can be derivatives of the U visa application. So U visa applicants that are 21 years of age or older, their husbands may qualify, unmarried sons and daughters may qualify. So U visa applicants under the age of 21, their wives or husbands, unmarried sons or daughters under 21, the parents and single siblings under the age or under 18 years of age. So another important note is the derivative cannot be the perpetrator of the crime. So an example is possibly like a son or daughter commits felonious assault against a parent, and parent applies for a U visa and is granted U visa. The child who committed the crime cannot, or the son or daughter who committed the crime will not be able to apply, be considered a derivative. And so the ages of the principal applicant and the derivatives are determined at the time that the application is filed for U visa status.
And in that example Annabelle just gave, if siblings and they were under 18 at the time, they may be able to qualify. But if there was a child who was also the perpetrator of the crime against a parent, they would not be able to qualify.
So now we're going to move along to VAWA. So what is VAWA? So VAWA is Protection for Victims of Domestic Violence under the Violence Against Women Act. So this provides immigration relief to victims of domestic violence. And Congress recognized that immigrant victims of domestic violence may stay in abusive relationships because of their immigration status, and it's often tied to their abuser. So VAWA is a form of relief in which a person can apply. It's called a self-petition. So they don't need to rely on the abusive partner or the abusive person to be able to to seek this benefit. So it removes control from an abuser and allows the victim to submit their own application. So throughout this, throughout the rest of this presentation, when we talk about VAWA, we talk about it being a.
So who qualifies for VAWA? And it's important to know that it applies equally to men and women, both in heterosexual relationships, homosexual relationships. Don't let the Violence Against Women Act confuse you there. It applies to everyone equally. But so it applies to abused spouses of US citizens and green card holders or lawful permanent residents. So abused children of US citizens or green card holders, or abused parents of US citizen son and daughters or green card holders. And there's some more complicated rules about the abused children and abused parents. So a non-abused spouse of a U.S. citizen or resident whose child is abused by the citizen or resident spouse. So it gets a bit more complicated, but I think the examples will illustrate it a bit more clearly.
Mm-hmm. And there are also qualifiers as to who qualifies as an abused, like for abused children, and also like who is a son and daughter. So there's specific definitions of child and son and daughter throughout this provision of the law. So VAWA eligibility requirements. So these are the requirements that a person must show to show their eligibility for VAWA. We're going to go into each one specifically, but first there has to be a qualifying relationship to a U.S. citizen or LPR, and you'll refer to the previous slide. And the person can also be an intended spouse, a widow, or a widower. And usually they have to be living in the United States. There are some exceptions, but the second thing is the person was subjected to battery or extreme cruelty by the abuser. So this also includes, it's physical abuse or emotional abuse, and either one does not have to rise to the level of criminal activity. The person must reside or have resided with the abuser. So they don't currently need to be living with the abuser, but they have to have lived with the abuser. And the last thing is good moral character.
So similar, exclusively on paper. There's no hearing in front of an immigration judge, and it's an application filed entirely by mail, and there's no interview required also. So the application includes, like the U visa, evidence, immigration forms, but there's no certification or anything like that. It's the most important evidence usually in VAWA is like objective evidence of the domestic abuse, if that exists, something like hospital records or medical records, and then a sworn affidavit of the abuse.
So we're going to talk about the application process and waiting time. So once the application is filed, the processing time varies. So at the time of this presentation, it could take from 3 to 18 months. Unlike the U visa, there is no cap on the number of VAWA petitions that can be approved or granted in the United States. USCIS can issue what's called a prima facie determination, which means that they, once the evidence is submitted, they believe the application may be granted. So the prima facie determination is not something, it's not an approval. So they can still deny the application, but it's just saying that what they submitted was enough for them to start consideration of the petition. And in some circumstances, an application for permanent residence can be filed at the same time. And we're not going to go into that in this presentation, but it's just important to note.
So as Annabelle hinted at the previous slide, so VAWA also provides protection from deportation and a path to a green card and even citizenship. So it also, along with that comes an employment authorization and some potential public benefits that are specially earmarked for victims of domestic violence under VAWA. And the action for 1 year can be renewed until the petitioner is eligible to apply for the green card.
So we're going to go into some more examples so you can kind of see how the different factors work. So Carmen was married to Kevin, a green card holder. Kevin physically and mentally abused Carmen during their marriage. Carmen left and filed a VAWA self-petition in April of 2016. After the self-petition was filed, Carmen called the police for protection during a subsequent incident of domestic violence. The police arrested Kevin and he was convicted of domestic violence, but ICE placed him in removal proceedings for a prior drug conviction. He was ordered removed on October 15, 2016. Does Kevin's immigration status change or the loss of his status affect Carmen's petition?
So the answer, oh, go ahead. So the answer is, in this case, in this example, it does not, but it could, depending on the timing. So here, because Carmen filed her VAWA self-petition before the loss of status of her abuser, it does not affect her eligibility. However, if she would have filed the self-petition after the after her spouse had her ineligible, unless she can show a connection between the loss of status and the abuse. And in this case, she likely could, even though his conviction was for a prior drug conviction. There may be arguments to the effect that but for his domestic violence arrest, he would not have lost his green card status.
We have another example. So Pam married Ava, a US citizen, on June 15, 2014. During the marriage, Ava subjected her to such mental cruelty that she moved out of the house on June 15, 2015. Pam later filed for no-fault divorce from Ava on June 15, 2016, based on having lived separate and apart from Ava. Does Pam's separation from Ava affect Pam's ability to file a VAWA petition? So we do not believe that the separation would affect Pam's ability to file a VAWA petition.
The timeline here is something to be mindful of, though. So Pam can file for her VAWA self-petition 2 years up until 2 years after the date of divorce.
Yes, so it is important to note that the date of divorce, but if the application is filed during the separation and the divorce is not finalized, that is also something to note. But is it like Mary mentioned, timelines and when certain things happen are very critical when doing an analysis of this sort.
Okay, so we have one more. We like examples. Lonnie filed a VAWA self-petition based on abuse by her husband, Jack, while her self-petition was final. So this is the example that Annabelle just mentioned. Can Lonnie file a VAWA petition after the divorce is final?
So yes, like Mary mentioned in the last slide, she's got 2 years from when that divorce was final to file for divorce. So so she could file for a VAWA petition as long as it's before 2 years before the final, or 2 years before the final, after the final divorce, or the divorce was declared final. My apologies.
So another follow-up question. So after Lonnie's divorce, but before the petition is approved, she meets the love of her life, Samuel, and she wants to marry him. Can she marry Samuel without it affecting her VAWA self-petition? And so the answer is no. It will affect her. A subsequent marriage will affect her VAWA self-petition, and that is something that she should discuss with her attorney, and maybe wait and get married until after her petition's approved.
I think we've got 2 more examples. So Kai was married to in 2009. During the marriage, Feng subjected Kai to physical and mental abuse. Feng died on April 15, 2016. Can Kai file a VAWA self-petition even though Feng passed away?
So yes, Kai has 2 years file the petition. So what would be the last, she would be eligible April 15, 2018 would be her last day to file. Follow-up question, if Feng was a green card holder and not a citizen, could Kai file a VAWA self-petition even though Feng passed away? And this is an interesting part of the law where they kind of left out green card holders or widows and widowers from protection in VAWA here. So the answer is no. But that doesn't mean you can't file while your green card holder abuser is alive. And this is just in the case of the abuser being deceased.
So Yoko married Jose, a US citizen, in a large wedding in front of all of their friends. Jose did not tell Yoko that he had never terminated his previous marriage and that he was still married to his first wife. Jose became so abusive that Yoko felt she needed to leave him. Although Yoko believed that she was legally married to Jose, their marriage was not valid. Jose perpetuated bigamy. Would Yoko still be eligible to file a self-petition?
So yes, Yoko is still eligible to file. For 2 reasons. First, because she believed that she was still married to Jose. She believed she was married to Jose at the time of their marriage ceremony. And second, because she was not she did not have 2 marriages at the same time. So it was her abuser. So yes, even if you are not, I forget the exact term. Annabelle, do you have it? It's like
Sham marriage?
No, there's a special term for these types of anyway, it doesn't matter. But yes, the point is she is still eligible to file even if she wasn't legally married. Their marriage wasn't valid because she believed that she was legally married for good reason. And this is something that would need to be documented with affidavits and other evidence. But it does not disqualify her in certain circumstances if there wasn't an actual valid marriage. So it's important.
That's our presentation for today, but we did want to leave some time for questions. So we're happy to take those at this time.
I don't see any pending questions. I'll give folks a couple of minutes to type them in if they have questions. That was really helpful. I think the examples really allowed us to explore sort of just how important the facts are. Mm-hmm. And there were definitely a couple that even I was like, that's really interesting. So thank you for doing that. I think that was really super helpful. To quickly remind, deadline for the US Census is September 30th. So if you haven't completed the census yet, we encourage you to do so. If you work with marginalized populations, we also encourage you to remind your clients to complete the census and just affirm and validate that it's safe to complete the census, and it's really important for folks to get that information in. A lot of times immigrants, folks that are maybe sort of have no status issues, but are just generally afraid of being in touch with authority, don't complete the census, and that impacts the resources that are available in our communities. So we encourage you to ask folks and remind folks to complete the census. I do see a question has popped in. I will read it out to you in just a second. Kanika, can you see the question? For some reason, it's not opening for me.
Oh, here we look. Does American Gateways have a wait list for assisting clients?
We do have a wait list. And you can, if someone wants to get on the wait list, we currently have a number they can call to make an appointment or just talk to our screening specialist, who will take down all of your information, and so all the attorneys can review it and then make a decision on your representation. So we do have a wait list, and we have a number of attorneys who consistently, we review the cases weekly. So if you don't get selected right away, come back and come back and come back. There's no limit on how many times you can try to get services. One of the other important things I just wanted to go back is that the U visa and VAWA protection are forms of relief that can be pursued along with other forms of relief like asylum or cancellation of removal. So if someone is, they can still pursue these forms of relief, and there are other forms of relief specifically for VAWA applicants that are in removal proceedings. But like I said, if someone has an asylum claim and they were all, say they are, they have a pending asylum application, but their hearing isn't until 2023, and they want to pursue a U, maybe for other reasons, for concurrent relief, even though it may take a very long time because it is a U visa, or for VAWA, folks should always pursue every form of relief that they're eligible for.
A couple more questions that have popped in. One seems like it might be client specific, but I'll read it out. How long does it usually take to hear back from immigration after submitting a U visa? There's a client this individual is working with who has not heard back since 2016. And at that time, they were notified that their application had been approved.
Well, I would definitely encourage you to contact your representative for the U visa application. But like we discussed earlier for the U visa timeline, it's not unheard of for 2016. Wait, so I'm sorry. So
actually, let me go back. I think it says it was accepted then, not approved.
I see, right. Okay. So, it isn't out of the ordinary at all for someone to, let's say, get that USCIS has received their U and not receive either an acceptance or a denial for 4 or 5 years, 6 years, 7 years, 8 years. So I would contact your legal representative, to check in.
It's also really important to note that if, this may be a legal service provider who's asking this question, but if it's an individual, when we do work on U visa cases, we maintain contact with our clients because move or their phone number changes, so it's important to know that they moved so we can update the address with USCIS. So maintaining that line of communication with the client is important. So maybe this individual moved, and again, I can't really comment on that specific case, but maybe the person moved and didn't update USCIS. Maybe there was some sort of note, and the person is not aware of it. But it's just really important to, if someone does move and they have a pending case, that they let their legal representative know.
We have one more question. This is about your wait list, actually. So if you're not able to assist someone, do you have a list of pro bono or low bono attorneys you share with survivors?
So we have, we can provide the number that the individual could call for representation. I'd have to check with our office to see if we have a list of pro bono or low bono attorneys. I'd have to get back to you on that.
I'm sure we have a list somewhere, but we just don't have it in front of us.
If you are working with survivors of domestic violence or sexual violence, you can also direct them to AFSSA. Folks can call our hotline. We work with American Gateways. We also work with a handful of other immigration attorneys that do some pro bono work, and then that also do some slight survivors with a range of other services that they probably also could benefit from. So feel free to direct folks to our hotline in addition to the American Gateways hotline as well.
Thank you.
We had a question to be a new Trinity. I think Trinity said she received her answer. That's all the questions we have. Minika, did you want to add anything? Or any comments or questions from your end?
No, I think we're good. Just a reminder, like Zara had said, please fill out your 2020 census and encourage others to do the same before the September 30th deadline. It matters for our community and especially for those folks who are from historically underrepresented groups. So just an extra plug for that. And you can go, if you want more information, you can go to one of the websites there, my2020census.gov or the Asian Complete Count Committee.
Absolutely. And if you don't already follow AFSSA and American Gateways on Facebook and other social media, please do so. We pretty regularly post informational videos like this one. So follow us and hopefully we can work together to serve this that we're all connected with.
And thanks so much, Annabelle and Mary, for joining us and for lending us your expertise. It was really useful.
And thank you, Mary, for sharing your little baby with us too.
Yes.
Thank all of you.
Thank you.
Thank you.
All right, thanks all.